honored to welcome our keynote speaker, Honorable Justice Shri Abhay Srinivas Oak, to deliver his address.
Good morning, dignitaries on the dais and young students. I'm really delighted to see so many students here on Saturday morning to discuss subject like law and ethics. I must compliment all of you. You are here and so many of you have written papers. When Professor Dr. Apurva Thakur contacted me and requested me to attend this seminar, perhaps she did not tell me that Justice Gautam Patel is going to be the first speaker, because Justice Gautam Patel is a great thinker and phenomenally good speaker. If I had known that, I would have avoided this invite, because it's very difficult to speak after Justice Gautam Patel speaks. I am not going to touch the subjects which are elaborately dealt with by Justice Patel, and especially the last part, which I feel that you should never forget. When we talk about law and ethics, we must talk about those who form part of the legal fraternity. Now, there are two important parts of legal fraternity. One, of course, judges, and second, members of the bar. Now, when it comes to rules of ethics for the judges and members of the bar, fortunately, the rules have been codified. As far as judges are concerned, there is a restatement of values of judicial life of 1997, and then there are Bangalore Principles of Judicial Conduct, which contains 6 values with elaboration. As far as members of the bar are concerned, there are rules of professional ethics formulated by the Bar Council of India. The rules are in different parts. First is duty of an advocate to the court, duty of the advocate to the opponents, and duty of the advocates to their fellow advocates. So there is a framework of rules of ethics which governs the judges and the members of the bar. Of course, by very nature of ethics, there cannot be exhaustive formulation of rules of ethics. I want to deal with practical aspects of rules of ethics. Firstly, in relation to the members of the bar. About a year back, I was invited to speak in a national law school, which was followed by a question and answer session. One question was asked to me by a very intelligent student. The question was, when a person is charged with allegation of commission of an offense, which is of heinous nature, it may be offense against humanity, it may be offense against the nation, or offense against woman, is it ethical for a member of the bar to appear for that accused in a trial? And second part of the question was, when an accused is convicted by a trial court for a very serious offense, whether it is ethical for a member of the bar to accept the brief on behalf of the accused to appear in appeal against conviction before the higher court, namely the High Court. Now, this was the question which troubled many students. Answer to that I want to give it here, because I am sure that that question may be there in your mind. When we talk about ethics, ethics cannot be divorced from the constitutional values or provisions of the Constitution. Now, we have one very important article inserted in 1976 in the Constitution, that is Article 51A, which deals with fundamental duties of citizens. The first of several duties enlisted is duty to abide by the Constitution and to respect the ideals under the Constitution. Now, when you abide by the Constitution, You have to abide by the provisions of the Constitution, and one such provision is most important provision under Constitution, Article 21A, Article 21, which says that no one can be deprived of his liberty except in accordance with law. So, when Article 51A says that you must abide by the provisions of the Constitution, how do you abide with Article 21? You have right to life, but the others have also right to life, and nobody can be deprived of his liberty without following the procedure established by law. Therefore, when a person is charged with an offence, a very serious offence, heinous offence, will be taken away without following principles laid down in Article 21. And Article 21, as you know, talks about according to a procedure established by law. By this time, you must have studied constitutional law. In Maneka Gandhi's case, way back in 1978, Supreme Court says this procedure can't be a simple procedure. This procedure must stand to the test of reasonableness under Article 14. It can't be a simple procedure. So, a lawyer is also a citizen, and therefore a case comes to him to defend such an accused. There is nothing unethical about it, because all that lawyer is doing is trying to uphold right of that accused under Article 21. And what follows from Article 21 is police or investigating agency may make allegation of commission of very serious offence, but an accused becomes a convict only if there is sufficient evidence against him which proves his guilt beyond reasonable doubt. That's the test applied, beyond reasonable doubt, and that's the procedure established by law under Article 21. So guilt has to be proved beyond reasonable doubt. And therefore, there is nothing unethical about an advocate accepting a brief of such counsel. Of course, if you see the rules of ethics, there is nothing which prohibits a lawyer to say no to a case. Nobody can compel him to accept a case. It is his choice, because it's a profession. Nobody can compel him to take a case. But if he takes up such a case, nobody can say that he has indulged in unethical practices. Now let us come to another conflict in the mind of the students, and that conflict is there in the minds of some of the young lawyers. Now take a case of, I'll give an example. A very sad incident happened in the city of Mumbai, where offence was committed against a young woman in a compound of a mill which was closed. The accused was convicted. Now question is, when there was such a heinous offence and accused is already convicted, there was a death sentence. Question is whether it is ethical for a lawyer practiced on the criminal side to appear for such an accused. Again, the answer you will get it from the Constitution. And again I repeat that ethics and Constitution go together. If something is constitutional, something you are required to do in terms of the Constitution, that doesn't become unethical. See, there is a conviction by a criminal court. I will give example of a death sentence. I give example of a case where there was a capital punishment imposed. Now the law is very clear that death sentence inflicted by a trial court cannot be implemented unless it is confirmed by the High Court. And law is also that even if that accused doesn't prefer any appeal, while deciding whether death sentence should be confirmed, the High Court has to consider his case for acquittal. The principle is that accused has a right to prefer an appeal. That right is conferred by a law which is framed by a legislature, which is again creation of the Constitution. That right to appeal is as a matter of right.